Is a wet reckless charge preferable over a standard DUI in the state of California? The general response to that or answer is yes, it is. Way better. Standard DUI has stronger negative implication towards your record. Versus a wet reckless, it could report to the DMV, but it doesn't show that you're driving under influence. It doesn't show that you had a .08 or above at the time of driving. It shows that alcohol was involved when you were driving in a reckless manner. It could still potentially count as a point, but not necessarily a standard DUI. And also the penalties for the criminal case is less severe. Instead of 3 to 4 years of informal probation, where you don't have to check into a probation officer or anyone, just behave, it's typically 12 months. You're looking at also lower fines and fees for wet reckless compared to standard DUI. And you're also looking at probably 0 to no jail time with wet reckless. However, just because you have a wet reckless does not necessarily mean that it doesn't count as a DUI in terms of the mechanics, which means that if you plead to a wet reckless, yes, which is an excellent outcome, it can still count as a DUI if you get another DUI, which means that if you get another DUI, that wet reckless could still count as a prior. But overall, it's still a better outcome to get versus a standard DUI with more severe penalties. If you're facing a DUI, it's important you get the right DUI defense lawyer for your case. At Shaw Law Firm, we're here to help, fight for you, and get you the best outcome for your case.